All right. Good morning, everybody. Good evening, good afternoon, whatever part of the world you live in. It's May the 4th, the year 2017. Schuyler Barbeau has a trial on June the 5th where this young Marine is going to be representing himself pro se. He needs our support. They're trying to make him out to be a domestic terrorist. So I pray that you all can fill that courtroom to let the judge know that nobody buys it for a second that Schuyler Barbeau is a domestic terrorist. Schuyler has asked us to read some legal motions. We've read several already, 24, I believe, and 25, and this time we're going to read number 26. So let's get to it, and I've got several more to go after this as well, and we'll just get them all up on YouTube, and we'll become acquainted with the Schuyler Barbeau case. United States of America versus Schuyler Barbeau. I should also mention that all of these legal documents have been placed in a DropBox folder, and the link is in the description bar. This is the defendant's motion related the government should be required to prove the defendant knew that the possession of a fully automatic short-barreled rifle was illegal. Note for March the 4th, 2016. The defendant, Schuyler Barbeau, through counsel, Assistant Federal Public Defender Dennis Carroll, submits this motion for a determination of the necessary elements required to sustain a conviction. In short, Mr. Barbeau ask this court to find that the government must prove that Mr. Barbeau knew that it was illegal for him to possess an unregistered short-barreled rifle that was also fully automatic. Number 1, procedural history. On December the 16th, 2015, Mr. Barbeau was indicted of one count of possession of an unregistered firearm short-barreled rifle in violation of 26 U.S.C. 5861D and 5845A3. The government has informed defense counsel that it plans to seek a superseding indictment charging Mr. Barbeau with an additional offense, possession of a machine gun in violation of 18 U.S.C. 9220. Both counts involve the same firearm and will be addressed herein. Trial is currently scheduled for May the 2nd, 2106. Again, that's a mistake. That's like 90 years away. Number 2, factual background. According to the complaint docket number 1, federal agents received information from a confidential source that Mr. Barbeau owned a short-barreled rifle. Mr. Barbeau gave the rifle to the confidential source so the source could sell it. Agents obtained the rifle from the confidential source and verified that it is a fully automatic, unregistered short-barreled rifle. After Mr. Barbeau's arrest, he admitted to owning the rifle. For purposes of this motion, Mr. Barbeau makes the following offer of proof. Mr. Barbeau does not dispute that he possessed the weapon described above, nor does he dispute that he knew the length of the barrel and the firearm was fully automatic. Mr. Barbeau would testify that he researched what he believed to be relevant federal statutes and code of federal regulations. Based on his research and conversations with others, he believed that he was under no obligation to register his firearms because he built it himself. He also believed that the federal law did not prohibit him from possessing a fully automatic firearm. 3, argument. Mr. Barbeau believed that the homemade characteristics of his firearm placed it outside the reach of the federal laws prohibiting possession of an unregistered short-barreled rifle and laws prohibiting the possession of manufacturing of a machine gun. He recognizes that the current Supreme Court and Ninth Circuit precedent do not require the government to prove that a defendant knew that his conduct was, in fact, prohibited under federal law, but only that the defendant knew that the firearm had the characteristics, short-barreled rifle and fully automatic, that brought it within the statutory framework. See Staples versus United States. Contrary to the defendant's assertion, the law does not require the finding that defendant knew the shotgun was illegal. However, it does require the defendant was aware of the features that brought the weapon within the scope of the act. Although it is generally true that ignorance of the law is no excuse, the right to possess firearms for self-defense is an important right enshrined in the United States Constitution, and in light of the confusing statutory and regulatory framework regarding firearms, the Ninth Circuit and U.S. Supreme Court should reconsider their previous holdings on this point. Dated 23rd day of February 2016. Respectfully submitted, Dennis Carroll, Assistant Federal Public Defender, attorney for Schuyler Barbeau. All right, that is document number 25. You guys say, how do you know it's document number 25? If you guys look at the top of these things, wow, I made a terrible mistake. Excuse me. That's document number 26. I'm glad I double-checked that. We've already read document number 24 and document number 25. This is document number 26. I correct myself. God bless. Write a letter to Schuyler. Let him know that you care about him and that you have not forgot about him. That's his address right there.